Welcome. And we now have Pete Holmes who's running for re-election to city attorney. So if you want to start with a 2-minute introduction.
Yeah, thanks again for being here tonight. I love this job. I tell all of the young lawyers that are coming up, it only took me 25 years to find the ideal job. Being the city attorney for the city of Seattle is really a dream come true. I got the 36 endorsement last time, 4 years ago, and would very much love to have your endorsement again. I don't yet have an opponent yet, but I take nothing for granted. In fact, on the campaign trail, this is probably the most fun part, talking to constituents, talking to people in the organized LDs, and in market contrast to asking for money. So this is the part that I love doing. I think I've shown over the last 4 years that elections matter. I promised a number of things having to do with both public safety as well as risk management, which are the two central functions of the city attorney's office. And in both of those cases, I think that I can safely say I've kept promises, and I haven't been afraid to take strong stands. And so looking back on 4 years, I would have never dreamed in a million years that we would have legalized marijuana, but I did keep a promise to stop prosecuting possession cases. That in turn has helped us to not be in the jail building business, even though, again, 4 years ago, it was conventional wisdom we had to do that. In 2009, the Judgment Claims Fund on the civil side experienced about a $13 billion loss in judgments and claims against the city. This year, it'll be $3 million. So whether it's public safety or the business side of the office, I love this job. I like to think that I'm doing a good job for the city of Seattle, and I hope they'll give me another 4 years.
Great, thank you. So now we have 5 prepared questions that we're asking all possible candidates in this race. So Liz, do you want to start with number 1, the city attorney?
What is the proper role of the city attorney in implementing the Department of Justice's reforms for our police department?
Great question that has been asked frequently. First and foremost, I, under the city charter, as the city attorney, have sole supervisory control over all the litigation of the city and all of its departments. Consequently, I, as Judge Robart, the federal judge that's overseeing the DOJ reform effort, said that we are still in litigation, even though we've entered a settlement decree, and that the city attorney represents the city of Seattle. That said, what I'd like to put everyone's mind at ease, if there's ever been a city attorney who was actually more inclusive than me, I would be hard-pressed to identify. Contrary to allegations, for instance, that I was trying to be the sole decision maker on matters affecting the police department, instead, what the truth of the matter is, I had actually tried to make sure that we had our city council fully involved in this process, because I think it takes a village, frankly, to reform a police department. And so the role of the city attorney, again, is as the chief legal officer, sole supervisory control, and I look out for the interests of the city, not just the mayor, not just the chief of police, not just any one constituency, but rather I try to make sure that the city, in its best interest, is embracing reform, moving forward. We have assessed the litigation appropriately, and that we can afford reform, that we can move forward. So it's one of those things, Elizabeth, that takes a daily balancing act, and I take it very, very seriously. I don't come to this job thinking I have all the answers, and I try very, very hard to make sure that I've included all the constituent parts of the city, and then, where necessary, I go forward and advocate a position and take a strong stand on it.
Sure.
Please compare the current city attorney's administration with that of his predecessor.
You know, first of all, we're talking 2 good Democrats. Tom Carr, like I, was a PCO in his LD. I was from the 37th, still am in the 37th. He was from the 34th. And Tom was a good guy and had 2 terms behind him. And I think the biggest difference is that I haven't been afraid to step out of what the conventional, traditional approach to something is. In other words, I haven't been afraid to try a new idea. I think that that's one of the problems that we face right now. You know, whether marijuana was the example I gave, and you know, public safety being a concern as a parent, a lot of people were afraid. You know, marijuana is bad. You know, and we need to somehow try to press it out. And so I said, well, but let's look at the data. How is that working? We know we spent $1 trillion on traditional interdiction methods, and it's just cost us a lot of money. And in fact, as of a few years ago, a 14-year-old boy could get marijuana a lot more easily than he could a six-pack beer. So it clearly wasn't working. So are you willing then to try something new? And I think that is probably the biggest change between Tom Carr and me, is that I haven't been afraid to say, let's explore what alternatives we have. Let's acknowledge what isn't working, like driving them all poor. Or are you serious? The city of Seattle really want to get on the bandwagon of being the #1 jailer nation in the planet and build a new jail? Can we really figure out a way to do something different? So I think that's the biggest difference. I wasn't afraid to depart from conventional wisdom and challenge the assumptions that underlie the status quo.
The relationship between the city attorney and the mayor has at times been colorful. How can these two offices better coordinate their activities in public positions?
I want to say first that the biggest disappointment of what I think has otherwise been an exciting first term has been my relationship with the mayor. The best that I can offer is that I think that Mayor McGinn would have been a lot more comfortable in a position in which he had responsibility for selecting and appointing a city attorney. I think it has been difficult for him to recognize that this office is an independently elected office with its own charter responsibilities, with its own ethical responsibilities. And consequently, I've worked very hard to try and find common ground. I've urged him not to ask the question continually, who decides if we disagree? And I say, let's wait until we disagree and then talk about it. So it's one of those questions that I, despite my best efforts, was unable to reach an accord with him. We do have a decent working relationship. We're going to be meeting with him this Friday. I continue to meet with him on a regular basis. I very much want the mayor to succeed because that means the city succeeds. And I would greatly prefer not to have these controversies played out in the press. And I will tell you that before the March 12th hearing in front of Judge Robart, where most of this came to a head, I had advised the mayor consistently that there's no clear answer to who has the final authority when there's a conflict, but that the battle itself would be bad for the city in order not to have it.
We'll go around the circle. David, would you like to read number 4 for the attorney?
How have budget cuts affected priorities and operations in the city attorney's office? As the economy recovers, how would you allocate additional funds?
Great question. It has impacted the office. For one thing, I inherited a budget that they immediately asked me to hand back about 4%. And that's been the consistent message every year, is that to take my base budget and reduce it further. So that's a trying circumstance for anyone, but especially a newcomer to office like me. What it has meant is that we have cut positions in the city attorney's office. I was also instrumental in helping to eliminate one department in the municipal court. We had 8 judges at the beginning of 2010, and by the end of that year we had 7 judges. And I think we've been able to do it in large part because it's kind of what Rahm Emanuel said, David, that never waste a good crisis like a recession. Because if nothing else, that has helped us to really focus our priorities and recognize that it's expensive to enforce an anti-state. It's expensive racism is expensive. And consequently, spending, for instance, $2,500 on average to collect $200 or $300 in traffic fines, which is what DWLS 3 is. It's a modern day form of debtor's prison. Is incredibly expensive. It makes no sense. And so we've been able to reform in a very good way by prioritizing. On the other hand, my lawyers are not making enough money. I'm very concerned as the economy is recovering that I don't want to lose good lawyers. And so I do need more money, and we'll be asking the budget office for more money to raise salaries.
List number 5.
That's okay.
That was my copy.
Attorney General Bob Ferguson recently filed a consumer protection lawsuit against a Tri-City florist for discrimination based on sexual orientation. Are there similar ways that the city attorney can protect civil rights in Seattle?
I very much supported Bob's decision to enforce the law and congratulated him on that. And we're always looking for ways in the city to further, whether it's consumer protection or employee interest. I think that the ways that the city can do it may be a little bit different than the Attorney General's. And so what we've done along the same line, we joined in the Galinsky lawsuit as amicus. That was a California Ninth Circuit case that overturned Prop 8. And so we have joined in that. We're now amicus with the Wilson case, which is what happened after, the Second Circuit kind of beat the Ninth Circuit to the Supreme Court in the rush to review same-sex marriage laws in the states, the equal protection analysis. So we're full on board with that. We have joined, we were amicus in the R71 petition in the Supreme Court, supporting then Attorney General Rob McKenna. And we're also amicus with in Arizona with the U.S. government supporting the rights of immigrants there in that state's misguided law.
Can I stop you for 1 second?
Yeah.
Can you define amicus for us non-lawyers?
Oh, sure. Friend of the court brief, where we join as a party, not as an actual litigant, but as an entity that has an interest in the outcome. And so we filed briefs that help further the correct position in the case. And so the city has served as amicus in at least 4 different cases like that. And I made that decision. So, Elizabeth, did that get all the rest of your question?
I definitely responded to I think it responded to the full question.
Great.
Great. So those were our prepared questions that we asked all the candidates. So we can just open it up now to any follow-up questions people may have. These are 1-minute answers.
Today, I spoke on behalf of the public financing campaigns initiative, and I wonder whether you might find its spending limitations in conflict with Citizens United.
Citizens United is a very troubling decision. I would love to see it overturned, and it's difficult to see. I'll tell you as an aside, I had some very interesting discussions with the ACLU, which I normally am on their side on most issues, and yet they of course were a component of the outcome of Citizens United. They may not have foreseen all of the impact of it. We think that there are some problems with Citizens United in some of the proposals that were being considered by the City Council. And to be honest with you, the initiative you're talking about, I'm not sure if it's going to pass muster. I support, the efforts to finance public campaigns to level the playing field, do all that. But precisely that, leveling the playing field, is what the Supreme Court has said is illegal in Citizens United. So, the Supreme Court is the supreme law of the land, even when they're wrong.
You had a very strong goal when you came in for 2009 of marijuana and the issues surrounding it, arrests. Do you have new goals for this next term? New ideas?
And a quick footnote, the marijuana issue, I never in a million years dreamed it would be this big an issue, and it certainly wasn't my main reason for running. It was police reform and transparency. Those were my reasons for running. But I found that when we were debating what is the will of the citizen in I-75, when the city had already voted to make the law enforcement priority, 0 is as low as you can get. And so, you know, the fine distinctions of the debate were ones that I grew tired of. And I said, look, let's just stop prosecuting these. They're racially disproportionate. It makes no sense. This is wrong-headed law. But you got to change the law. You can't just simply not prosecute. Going forward, talking about changing the law, we need rational, responsible gun control. And I will work very hard as an initiative that I'm going to be supporting, just like I did Initiative 502. We need to move forward in this office, reforming this office still further. And frankly, I'm drawing a blank on my last reformer that I wanted to tell you about. But we're working on DUIs and, you know, hoping to take advantage of Inslee's last-minute bill. And it's our lawyers, as you know, have been in Olympia working on that.
AG Bob Ferguson has been focusing some resources in environmental prosecution and protection. What is your office doing to protect the environment, and what type of kind of cases and initiatives are you working on?
Just this week, I agreed to join the city as amicus in the challenge that the city of Snoqualmie has raised against the county on the Growth Management Act. And I think that's probably one of the more direct, environmentally sound steps that I can take in an office that ordinarily doesn't deal directly with that. But I have been very supportive in trying to get county collaboration on things like the Duwamish cleanup. We have recently engineered a consent decree with the federal government to clean up the Duwamish that shows, I think, the really smart trade-offs going forward. And we're doing the same thing, frankly, it's not environmental, but under ADA, we're negotiating a consent decree with the Justice Department about all city buildings and parks. So environment I very much care about. You know, I was with NRDC before I went to law school, and I remain committed to helping do what I can to make it a better environment.
Thank you.
Great. Additional questions?
I'm just curious. You mentioned salaries for your attorneys. What is the salary range for an employee, a lawyer?
Sure. The entry level is around 58 to 62,000 a year, entry level. And we have a number of lawyers that are making at that level. I have some in the criminal division that are too highly paid. By that I mean they've been with the city over 20 years, and you don't need $110,000, $115,000 misdemeanor prosecutors. And so I want to see that office come more into line with the civil attorneys. Public Records Act, private lawyers are making amazing sums in that, and we have 3 of the best Public Records Act lawyers in the state, and they could all be making twice what they make right now if they were to take a private offer. So I'm very concerned about keeping those dedicated servants, you know, public servants in the office and contributing to the expertise. So, you know, I'm looking at as much as a 10% ask of my budget, an increase.
We have time for one more question.
Just to follow up on the earlier question about campaign finance. In the early part of the Citizens United decision, it talks about, with great solicitude, I think, about corporate speech. And it uses the word repeatedly, chilling, such as sort of have a chilling effect, or would chill free speech of corporations. But that usage is asymmetrical. It's not used with respect to public, private speech of individuals. So I wonder if you might see some kind of opening in that usage with respect to the campaign finance movement that is afoot.
You know, the first disclaimer is I'm not a First Amendment lawyer, and yet I'm very intensely interested in this. It struck closer to home, in fact, in Seattle with the defense of the Yellow Pages ordinance. If you remember that, Seattle had come forward with a pretty progressive ordinance to help reduce not speech, but just solid waste. You know, all of these phone books get dropped on our doors. And the Ninth Circuit struck it down. and in a way that all but eliminated the commercial speech prong of First Amendment analysis. And I found it really disturbing because they all but eliminated it. Under First Amendment analysis, no prior restraint for clearly, you know, the public, the Hyde Park, if you will, bully. But commercial speech is allowed to be regulated. And so, to me, it's ironic that they all but eliminated that distinction in striking down our Yellow Pages litigation. It may be the trend of conservative jurists going forward. I don't know if that helps.
All right, so with that, Tim, if you want to take 30 seconds to close the statement.
You bet. One quick comment to make in reflecting on the last 4 years and in looking ahead at police reform. I'm extremely excited about police reform. Despite all the headlines and the like, Seattle's positioned to just really move forward in a great way. And so I am only optimistic. I have no ill will or harboring grudges with the mayor or any of what we had to go through, because every city that goes through a federal mandate has gone through a very similar grieving process, if you will. There's resistance and the like. But in my case, we looked inside first. I looked in the mirror first, and I worked to end this 40-year no-bid contract where an outside law firm defended all of our lawsuits. And I think that alone has helped bring more information in and risk management for SPD.
Great, thank you very much.